Welcome to Entertainment Law Questions Asked and Answered. I'm John Garon, Dean of NSU Shepherd Broad College of Law, and I'm here to answer a question that I often receive about collaboration agreements, or more frequently asked as, what do I do when a friend of mine suddenly claims to be the co-author of my project because of a little advice I was given? This situation occurs very often for authors, artists, inventors, and others who find themselves with unwanted partners, and it's very easy to manage the situation by establishing a collaboration agreement in advance with any actual co-authors or co-inventors, and using this as a tool to exclude those who should not be part of the creative team. So the need for the collaboration agreement really sets out what the collaboration is among the co-authors. It creates an ability to protect the trade secrets among the co-inventors and establishes the rules for protecting those trade secrets. It helps specify the roles for each of the collaborators in the relationship. And most importantly, it provides very strong evidence that third parties who seek to inject themselves into the creative process are not really members of the collaboration team, and so they're not entitled to any of the rights. And then finally, it allows those who are collaborators to establish the rules of their ownership, control, and compensation. There are a number of provisions that go into a collaboration agreement, but the key here is to make the agreement as short, simple, and plain as possible so that the parties understand what it is and no one feels like members of the group have lawyered up and made it difficult to understand. I'm going to spend just a minute talking about the different parts of the agreement, but of course each one of these provisions can be developed in more detail. So obviously we need the name of the parties and the name of the project or the work that is being developed. And then we need the role for each party. Now, if they're joint authors on a creative work, that may be very straightforward. In a musical, we have someone who is writing the book, which is the written text. We have someone who's writing the lyrics to the songs, and we have a composer. That's very typical roles. And then, of course, later we'll add choreographer, director, and the like. For programming, we may have a programmer and a graphic designer. And in other projects, there may be very many different other types of individuals who are involved in the collaboration. This is the place to set out where each type of member in the collaboration and what their particular role is. This is also an opportunity to set a preliminary assumption of the ownership interests of each member of the group. They may be equal or they may be unequal depending on the amount of participation, but this can be specified at this time. There should also be a written policy about how to bring on additional collaborators. It may be appropriate to bring on additional collaborators, but it's important that the document specify that that requires the unanimous written consent of all parties. In this way, someone who claims to have helped out and become a joint member can't overcome the requirement that there is an agreement by all the parties and that it had to be signed in advance. Next, we have confidentiality provisions. This is particularly helpful if there's going to be an attempt to sell an idea or a trade secret down the road, because it establishes the ownership of those ideas and makes sure they haven't been given out to the public, which would destroy their unique value. The document provides an opportunity to establish milestones for the group, identify measures, and so if the group is not functioning fast enough or it turns out that the project is not viable, these provisions will allow for the termination of the agreement because the milestones aren't met. It also allows for the group to establish how long the relationship is going to last, and that's particularly important if this is a project that does not result in a work product and outcome, so that it doesn't languish for years and years. And then there should also be provisions on how to dissolve the group when the term is over and how to resolve disputes. I strongly recommend that in collaboration agreements, a commitment to mediation is the first step. So each member of the collaborative team is agreeing to sit down with a neutral and the other side and work out their differences. Most often this can be done. It's also much, much less expensive than going to court. If this doesn't work, then the document can provide that the group moves to arbitration, and I recommend a particular type of arbitration known as baseball arbitration. This allows each side to present a single outcome, and the arbitrator is forced to decide which is the better of the recommendations. The arbitrator can't split the difference, and it tends to force both parties to be much more reasonable, and oftentimes leads to a settled negotiation among the parties rather than letting the arbitrator decide. There should also be a way of modifying the collaboration agreement by putting in a writing that's agreed to by all the parties, and then of course it needs to be signed and dated so it has enforceable legal effect amongst the parties and provides that great source of protection against third parties. Again, third parties intruding into the collaborative process is one of the bigger risks that creators run into. And so by specifying how one becomes a member of the group, it provides strong evidence that somebody from the outside was not an actual member of the group. And it goes a long way to eliminate those problems as they pop up, and they so often do. Finally, its use in business and law is very clear. Under copyright law, it establishes a joint authorship between the parties because it demonstrates an intent of the parties to create that collaboration. The same thing is true in the patent world as joint inventors. It provides documentation that steps were taken to protect trade secrets from a trade secret perspective. And for industry, whether it's a record deal, a motion picture, a publishing agreement, software, or a new invention, it helps establish the chain of title that the idea was owned by these particular people starting at a particular point in time, and so it creates a start point for all of the rights that are necessary to protect that idea through its development into a working project or prototype and to be sold to industry. It is a very simple agreement to put together, and it solves so many problems that often trip up inventors and authors on their way to creating excellent works. So I strongly recommend that a collaboration agreement is made by any group going in to develop their project. I will note that I use collaboration agreement rather than partnership agreement. Partnership agreement is a creature of state law and has financial obligations that are not part of the collaboration agreement. So one of the provisions specifically states that this is not a business partnership. Now, it may be that the collaborators want to create a business partnership, but that would be a separate document that we can talk about in a different Q&A. Again, I'm John Garon. Happy to answer your questions asked and answered. My books are below, and please feel free to contact me with follow-up questions about this material. Thank you very much for listening.